Happy Wednesday. Welcome to Why with One Stop. This is what went wrong in February. It's the file recap of how we got it right and how we cleaned everything up. I'm Sam Hayes, am licensed transaction coordinator, realtor, all that fun stuff. Been doing this for over 2 decades in Southern California. I've assisted with over 7,000 transactions, all my usual alphabet soup. Please, as always, verify all with the broker of record of the file you're working on. We're just going to kind of go through a quick recap. This is one of my more relaxed presentations, kind of just here's what's happened. Here's what you should be aware of. These are some of the problems I'm seeing when I'm out there working on files. This comes up a lot. When I'm working with new clients, I really like Glide. Glide is great because it is easy to. Okay. Okay. Good. Didn't start yet. Yay. I don't want to annotate. I'm gonna have to audit all of this. This is fun. Happy Wednesday. Welcome to Why with One Stop. This is the recap of the month, what went wrong in February, and how we got it right. I'm Sam Hayes, and I'm going to share with you a little bit about me in case you haven't joined one of my webinars before. I've been doing this for over 2 decades here in Southern California. I'm a CAR certified transaction coordinator, certified forms trainer, realtor, notary, certified in short sales, all sorts of other fun things. Basically, if there's a reason to get alphabet soup behind my name, I'm in for it. And this is my monthly recap of what I learned, saw some red flags, some issues, and some problems on files as we were going through them. As always, verify everything with the broker of record with the file you're working on. We're going to start off with talking about adding a TC in Glide. And there's a couple of quick steps when you're an agent that it's very easy to do this. I like working in Glide with my clients. I'm not as big a fan of Sure. I think it's Secure Sure or Sure is Secure, whatever it is for zip forms. I think Glide asks better questions so far. They all could be better products. As we know, there's always something missing in tech that we wish there was a little bit this or that. But to get you going through it, if you're going to be adding a TC to work with you in Glide, that way you can share the forms, both have access, see all the history of what's going on working together. You're going to go to yourself right here. So when you go into the main page, you're going to click on your photo or your initials if you don't have one. You go to account settings. Then you go into scrolling down to account preferences. You'll see it down below, assistants and TC. You'd enter in the assistant or TC's email, and then they would be part of your transaction. Now you need to remember, you've got to invite the TC to the transaction or they will not have access. I'm going to do a more in-depth going through Glide, some of the tips and tricks that I've seen. That's one of the videos I think I'm going to be doing in April. Is there anything, let me know if there is something about Glide. Do you have a specific question, issues, or what's been some of the challenges you've had working with it? So far, still one of the best products we've got there. I know it makes people crazy. There are ways around things. I've got a couple of ideas that might help you out. So keep an eye out for that video coming up. I run into this over and over and over and over and over. Trusts don't have hands. Neither do LLCs, corporations, anything along those lines. So when you are having documents signed, it needs to be in the name of the signer. I like to do, because my notary brain hops in, comma their title. So there's never a question if they're signing on behalf of themselves or the entity. You're never going to have LBC entity be the signature. If you see anything where it's like 1, 2, 3 trust, and that's the signature block when you get your Docusign or anything, that's incorrect. That's not a valid contract. That entity doesn't have a hand. It can't sign its name. That's why you have a managing member, a president, a successor trustee, an executor, an admin, anything along those lines. So one of the ways, I know it sounds silly, but it gets people's brains to engage, trusts don't have hands. They cannot sign. Make sure you're getting the right information. I also run into a few problems this month where it was an ongoing situation of, I need proof they have signing authority. I can, as I've discussed, swear up and down that I am the Queen of England. And that document that you have from escrow that says I signed it, and it was notarized. Yeah, well, the notary is only validating that my signature matches my ID. The notary is not validating all the contents. Nobody is validating that. That's why I have such an issue. And like, this is my glittered soapbox that I lose my mind over. There is not proof. That's why you have in the LLC, in the trust, in the docs from the court, there is always a document that explains this person has signing authority. It exists in all of these created entity documents for this exact reason. Real estate is one of the few places that goes, oh, no, we don't need it. Oh, no. No, it's because people aren't familiar with it and comfortable with it. They don't know what to ask for. And nobody wants to look silly. So that's why we're going to talk about it, because I don't want you to look silly either. I want to make sure you know what to ask for. In a trust, it's typically the certification or declaration page. It does not tell me who gets the cat. I don't know who gets what money. All I know is who's allowed to sign on behalf of that entity when we're dealing with real property. That's one of the biggest things. Same thing with your LLC docs. I need a list of who are the managing members, who is required to sign. Can one sign without the other? I need the letters of administration from the court. I need to know who can be the executive. All of these things exist for this reason. So make sure you're getting that document. It's RPA, I believe, 32 that states in little parentheses, I close parentheses, I need those docs. And then have that conversation when you're taking your listing. Pull the property profile. Oh, you're in a trust. Let's get a copy of the trust. Let's send that over to title and double check. I just had one happen where somebody recorded while we're in the listing period, and suddenly we now have 3 other signers that we have to add to everything. Have these open communications with your clients, especially when you're dealing with entities. They're wonderful things. They exist to protect our clients, but at the same time, we need to know why and who gets to sign and how they need to sign. Very basic. Get it handled in the beginning. We get title will take a look at that for you. They'll streamline it, let us know exactly what signature block we need. You can put that into Docusign. You can have them sign it, whatever you need. But get the information, ask the questions, get a little bit more info. Make sure you're being on the up and up, because unfortunately, as we all know, shenanigans happen out in the universe. This was another one that came up a couple of times. What's the difference between a notice to perform and demand to close escrow? Well, I want to close escrow. Well, they haven't removed contingencies. Well, I want a notice to perform. Well, they've already removed contingencies. So the thing is, notice to perform is performance. That is performance within the contract. You can do that prior to 2 days. It's set. It used to be back in the day, those of us who remember when we only had 8-page contracts, people could put hours and it was 72 hours. And then it switched to days and suddenly we had 72-day contingency notice to perform. That was crazy. So it is default 2 days, and you cannot demand performance on a weekend or a holiday. And you got to remember, they have until 11:59, the date of performance. So we're noticed to perform. We know it's up Monday. They still have till 11:59. You can cancel Tuesday morning, but they've got per contract, because our days run until 11:59 p.m. You can send it 2 days prior to when it's going to be due. So if it's due on Sunday, even though we can't demand the performance on Sunday, we can send it on Friday. They don't have to do anything about it until Monday. Confusing, I know. But one of the things is that's why you've got to really look at your dates. You got to look at your time frames. You got to look at your days and have a clear communication about it. But make sure that you're not doing it noticing more than 2 days before it's due, acknowledging that if that falls on a weekend or a holiday, they have till the next business day till 11:59 to do it. Same thing with your demand to close escrow. This is now all the contingencies are removed and we want to be done. We're ready. It's time to close. You guys are dragging your feet. I don't know what's happened with your loan, the move, whatever. We want to close. Same exact thing. It's after all the contingencies are removed. There's 3 days per RPA 14C, and you can also issue it 3 days before. Same rules. No performance on a weekend or holiday, 11:59 to perform. Make sure you're paying attention, make sure everything's in compliance before you're sending these out. If something is wrong on the notice to perform, they recently changed the form when we did the revision. Used to be if you boo-booed one part of it, whole thing was screwed. It only applies for the items that are actually in effect. If you haven't delivered something, they've only had the HOA docs for 3 days. Suddenly we forgot the home hardening. Well, that gives them more time, and you can't demand a contingency removal until the seller has performed all these items from the buyer. But everything else still has to happen. So make sure you're paying attention with little itty bitty details, but those are the things that can make a huge difference, especially when you're dealing with an issue of closing, deposits, all of that stuff. I highly recommend working with a transaction coordinator, myself or anybody else. This is what we specialize in. This is why you have TCs, is we know the ins and outs of these forms, and this is what we're focusing on so that we can be aware of. Also remember, agents can't just go, I'm sending a notice before. You're not party of the contract. Your seller has to be willing to do that. Also, once a notice of perform has been issued, even if the seller does not cancel, that's still live. That's still going. So until the performance has happened, the contingency has been removed, the disclosures have been returned, the proof of signing entity has been returned, because you've got two lists there. You've got contingencies and contractual actions in your notice to perform. Till that's done, if the seller lets it ride, that's fine, but the seller can then cancel if it's after the time frame of those 2 days with that full business day to perform when it's due. It's a lot. I'm going to do a separate video on this topic as well, because I think we need to go into the differences on the forms when they apply, how they roll into the contract, and why it's such a big deal, and where there is legal exposure and potential. So that'll be another April topic as well that we'll go into. This is a fun one. Tenants in the property. Well, it's my cousin, it's my daughter, it's my nephew, it's my sister, it's my brother's cousin's sister. If they are over 18 and not on title, they do not, they are not an owner. They have got to, we've got to do a TOPA. TOPA, tenants, tenant occupied property addendum. Well, Sam, they're only gonna be there for a day, but it's fine. They're on their way out. If they are there for 1 minute after that contract is executed, with everything that's going on in tenancy laws, you need a TOPA. You can also clarify in there that they will vacate the property, or if they're remaining, if you do have tenants that are staying after for some reason. And if they are remaining after the fact, this is the one we ran into. So we've got a seller in possession after closing escrow. We got an SIP. That's the seller. That doesn't address tenants. We had to do a TOPA stating the tenants were going to remain for the length of the SIP, even though they're not going to become tenants, because the buyers partially are becoming housing providers. Still learning all the new words. The buyers are becoming housing providers partially during that SIP, because you've got both your less than 29 days, so we're not in a full housing provider tenant situation, but then we also have tenants who are already in a housing provider tenant situation rolling over. It gets messy. It gets really messy. So pay attention, have a conversation with your clients, see what you can get planned out. We got it sorted. It took a little bit of playing around with all of this. But if they are over 18, not on title, and in the property, technically those are tenants. Those are not family members. Kids under 18, that's different. So everybody over 18 got to be on title. If not, then you've got tenants and you've got to use your TOPA. Anytime, and make sure you're asking these questions, finding out, looking around when you're taking the listing, looking around when you're showing the property, see what's going on. Let's get some clarification. It's not offensive. It's not, I don't want to upset anybody. It's a, hey, what are we dealing with here? How do we make sure everybody's taken care of? It's showing concern and clarity, and also that transparency thing that the whole NAR settlement is based on, and we're supposed to be complying with. Something to take into account. Okay. BRBCs, please, I beg you. I beg you. Oh, wonderful realtors out there in realtor land, and your brokers beg you. If you do not have one of these signed prior to going under an executed contract, you are now violating California state law. I'm going to say that again. You are violating California state law, AB 2992. Now, as we discussed before, the difference on the SBBB and the NAR and what's all of this fun stuff. Here's the deal. NAR settlement agrees that you're going to do it prior to any act as an agent. California law, AB 2992, prior to execution of contract. I'm a paranoid freak. I'm going to tell you to be conservative. You should do it prior to. We are ending up, we being the TC community, are seeing more and more and more of people not doing these. One, it's in the RPA, I believe it's RPA 18. Seller does not have to pay you because buyer is now not acted in good faith. Buyer said that they have this document fully executed. Seller doesn't have to pay unless it's executed. That means give that credit in RPA 3G3. So suddenly we've got a buyer's agent who's not getting paid. We've broken a law, and now we're not in compliance with NAR and could get sued. Fun. Get these reports or get these documents done. If you are concerned, you can do the PSRA, that's property showing representation agreement. That's for like 3 to 7. That's 30 days. You can make it, that's kind of like the SIP to the RLSA. Easy peasy. Or somebody said urgent care versus ER. There are ways to do this. I understand it's not something that we've been doing, or you're out of practice, or you don't feel comfortable. Get comfortable. This is a state law. The other thing is if it's not properly completed. Well, guess what? I need to know where you're showing those properties. So if your location section here, if this is empty, then we got a problem because you really have no grounds because you haven't narrowed down where you're showing. Now, let's not, again, as I've discussed before, California is a very big state. So the likelihood of you showing in Northern California and Southern California, unless you're at a certain price point and the Learjet is waiting, then probably not going to be able to do that. Even Southern California, trying to show out in Imperial County, up in San Bernardino, then going into, what is it, YOLO or whatever, and then coming back down to San Diego, Ventura. That's a lot of ground to cover and a lot of traffic. Likelihood is pretty low. So you're going to want to make sure that you kind of look into that. Cynthia, I just saw your question. So for the entity issue, it's part of the name of the document is authority to shine. Yes. What you should do is that, like we talked about, the particular name for the document, it depends on which entity it is. You're going to want to go ahead and get the certification for the trust or the other documents as we discussed. Anyway, circling back to this. It's a big deal to make sure that you have this Goldilocks special is the easiest way to explain it. We don't want it too broad. We don't want it too narrow. We want to find your just right sweet spot. Take a few moments, go through this document with your clients, explain to them what this is about, explain to them how you'll be able to ask for a concession from the seller if they are unable to financially pay you with their purchase. Also, make sure you are obtaining those financial documents. Those are part of what's supposed to be provided within 5 days per the BRBC. You should be talking to the lender. All of these things. Buyer's agents need to take these documents very seriously. I'm seeing a lot of them being thrown through because people weren't doing files, stuff starting to pick up. Make sure you're comfortable with it. I have several videos on the BRBC on my YouTube. I'm happy to also walk you through it. I'm happy to do a specific video or come do a training anytime. Let me know, but this is a really important form. It's going to protect you so you're not wasting your time. Okay. So yes, because the thing is, if the buyer is the agent representing themselves, well, but they're representing the brokerage. So remember, a buyer is working technically with the brokerage. The brokerage gets the commission. So the brokerage still is going to need to have on file this agreement, because what if that buyer has a wife or a husband, or they're buying with a partner, or even the entity is not an agent, if they're buying in their trust, then you're going to want to make sure that you've got this on file. You can note buyer's representing self will credit back, but verify with the broker of record you're working on. I would want to have them on file to make sure that you've gone ahead and documented in case you got audited. That's the other issue. They can always go back. You just do a modification of BRB, the MTBR, modification broker representation. We're going to use the commission. We're reducing the commission. Only on this file, it's doing this. The broker says this. Now, granted, remember the other thing to remind yourself, when a buyer or an agent is representing themselves either on a buy or a sell, E&O typically will not cover them. Always verify with the broker of record if they allow that, or if they will require a different agent to represent them then typically it needs to be a certain fee. You'll have to verify with that E&O for that brokerage to make sure that it's in compliance. It's usually best practice to have a buffer between you and the other person. This is an emotional thing, and owning property and working in our industry, things that we react to or know about or think are common knowledge may not be on the other side. And you've got some extra exposure there. So talk to your broker, get the info, but I highly recommend not representing yourself if you can avoid it, especially if you're on the listing on the selling side, because California law sides always, typically with buyer tenants. That's the way it's written. It's always more on their side than it is on the seller side. So double check that with your email and broker of record of the file you're working on. Please, 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 please. We need the property address in the subject line. The only thing that doesn't typically change in a transaction is the property address APN. Something, but the property address is usually faster, even if you just got to throw the street name in there. I know as things are picking up and we're forwarding things off of our phones and everything else, it really saves so much time. It helps with communication documentation. I can make sure that I know what's going on. It stands out in my inbox. If I'm working on that file, I know where I'm looking. I can sort, I can get everything organized. It's much faster. I cannot beg you and if you start to have multiple escrows at the same time or a listing in an escrow, it really helps with the clarification. I'm going to remind everybody over and over again, back to the basics as things start to pick up, get that property address in the subject line. It's just too important. Okay, so what else we got here? As soon as you take on your transaction, as soon as you start writing an offer and you get your BRBC, I've got all my clients sending them over to me just like they do their listing. As soon as you get that listing signed, send it over to me. Send it to your TC. Get it to them as quickly as possible. The sooner we can get started on disclosures, the sooner we can start finding out. Let's find out about the solar. Let's find out, is there a weird HOA? Do they have a third HOA? Is there one for the electric, the plumbing? Who knows? Do they have extensive documents that they need to get you? The trust documents, a history of what's been worked on the property. Maybe they have previous disclosures. The sooner we can get to those now, while the seller is engaged, they're excited, they want to get going on stuff. They have been waiting and has been sitting on the market. Stuff's not in a pod on its way to Minnesota. Had that happen. They can get things over. We can get them scanned. We can get them reviewed. If we have questions with title, find out, hey, oh, I forgot we had this deed. My dad loaned us some money. We need to do this. We've got to make sure that this is sorted. It gives everybody a chance to breathe and start thinking. And that's the best thing you can do is give your clients a chance to do their highest and best, and you do your highest and best when we're not rushed, we're not panicking, and not everybody's going, oh my God, we got to get this deal done, and we've got a 5-day turnaround. And yes, find out if the person you're working with is actually the seller. That's been fun. That's been a fun one. I've had that happen a couple of times too. That's been a very interesting, as we know. Get the information, get the property profile, do all the extra. I don't have time. I'm too busy. You need to make the time. You need to take those moments. The 5 minutes now are going to save you 3 to 4 days on that closing. The quiet and knowing it's handled is going to free your brain up to take on more deals. You will be more efficient if you stop. If you need a checklist, I've got checklists. I can give you a checklist of what you need to ask. We can get you anything you need. But let's do it by the book. Let's do it in order because that's what we're setting you up for. All of this has to go to court at some point, potentially. Every file I look at that it has to go to court. That's how my mom trained me. I am always looking at what is going to be the exposure, what's going to happen. And going to court doesn't mean you're going to get somebody who's interested in real estate. They may not know anything about realtors at all. You don't know. So the more we can show step-by-step, clear communication, clear process, standard, highest and best care, the better off you're going to be. So let us get involved and let's be on your team as soon as possible. Docusign. Oh, my goodness. Okay, first of all, it's gone down a couple times this month. I don't know what's going on, but it's decided to be cranky a few times, which I know none of us have time for. First one, if I am not one of the original recipients, so if I originate an envelope, I'm typing up a contract, type the contract. I've sent it out for everybody to sign. It comes back and there aren't PDF attachments in the email. I cannot forward that envelope to somebody who is not originally a signer or recipient. That's part of the benefits of Docusign. It locks it down. That's why we use it. It's part of the EULA. It shows all the electronic signatures and only these people had access. And this is when they had access. So don't be forwarding that. If you don't put them on, and you can set it up and I can show you, and that's probably another video I should do about how you can set up people to be CC'd once it's signed. You can set them up in numerical order. It's wonderful. And then you've got a time date stamp. We know when it was delivered. We know who got it. Stop forwarding emails from Docusign unless all those people are on there. It won't work. It won't. It'll make everybody crazy. The ones you can forward have attachments. But Sam, why don't I have attachments on this one, but this one? It will only attach up to 5 MB. So you have to be all the PDFs that you put in there for signatures or all the documents, all of that whole envelope size has to be less than 5 MB for the different documents to be attached. And then you can forward it just like you would any other email with attachments. If it is over 5 MB, you must log into Docusign with the email address that was sent to you at. If you have multiple email addresses, it won't work. And even if you don't pay, well, Sam, I don't pay for DocuSign. I can't log in. Yes, you can. If you are a recipient on that envelope, you have a recipient account. You get to access that document. That's part of what we all pay for having DocuSign. Well, it's got a password. Hit forgot password. I don't ever set passwords for this reason. I don't want to know your password. I don't want to be part of it. There are ways to do this. So the panic's, I can't get out of it. Don't panic. We can get you through it. Same thing when I hear, well, the envelope's expired. You have to resend it to me. No, I don't. If you look at that email, there's two options. One, click resend. It'll come to you in about 5 minutes. Two, log into DocuSign with that email address that you received that envelope at. You go to manage, inbox, bada bing, bada boom. It's waiting right there for you. Yep, I guess I'm planning April as I'm talking to you guys, because obviously these are ones I should do videos on. But this is what we're going to be, this is the little things that people panic about, and it's just not knowing it, and nobody wants to ask. So quick video, I'll make it easy and peasy for you. Super cake, it's what we live and breathe in. But take a moment, read the envelope, read the emails, read the envelopes, and pay attention to what you're doing. Biggest thing I can tell you. And if you're still not comfortable with it, call me, I'll get you through it. Multiple counter offers. Ah, yay. We've got stuff going on. We've got a little bit more inventory coming up. Awesome. It's not accepted till the seller accepts the buyer's signature. Because remember, you got multiples. So you've got two buyers going. So both buyers can sign, but seller still gets to decide. So till Section 8 here is signed and then returned based on what you've got on the RPA for the return of the electronic delivery, it's not an executed contract. This isn't accepted. And that really can mess with timeframes. They can delay things. They can change your entire situation of a file. So pay attention, get whichever one they're accepting. You could have 2 multiples, you could have 20 multiples. Be a little crazy, but you can do it. I've seen it. Make sure the one you're accepting is here. Or if you're putting it in the backup position, it still doesn't count until this. And you need to attach a BUO. But stop, breathe. Let's get everything done right so we have it all cleaned up. This is also why I'm a big fan and going to keep pushing. Keep the entire contract together. I understand your client's busy. I understand you're doing multiples. I understand you're on your phone. I get it. I do. Here's why I'm going to tell you, you really want to keep all those docs together. One, anything that's not initialed or called out, including mediation arbitration, doesn't count. It's not valid. It's not technically included in the contract. So you can have a fight on your hands for that. Two, you could be countering to the wrong person. Seen that happen. It's not good, or wrong terms. Always good to double check against it. Three, have you done your fiduciary and provided that contract to your seller? What if the other offer was better? What if the seller gets mad and thinks that's what they should have gone with? If you don't have the proof that you had them all sign, how are we going to defend this file? That's the way we need to be thinking. I understand. I got to do it. I got to go. Yes, you do. You got to go. But take 3 more minutes. Half the time, if you can run this through Glide, it'll automatically populate it for you. It's very easy. Take the time. It's really going to save you on that back end, and it's going to get you those more deals. I promise. I've seen it happen way too many times. So double check. Multiples are not executed and not accepted until this is signed and returned to the other side. Something to stay aware of. Okay, so some of the just miscellaneous ones that came up after I'd made my slides. I see a lot of agents, older agents, kind of doing the agent recommends that you get a physical inspection, agent can't blah, 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 blah. Verify with your, and your broker of record. My understanding from risk management training through everything and going through stuff, that is deferring your civil code responsibility of 2079. There are technically now only 2 civil code required things. One is the home hardening and also the agent's visual. The act of the agent's visual is not required. The AVID was created to document this so you can prove that you did your civil code responsibility, which is to walk the property. That's why they say don't do sales out of area. It's not that your broker's trying to limit you. It's because you are supposed to have knowledge of that property. And if you can't go do your AVID because you're 400 miles away, you really shouldn't be listing that property. Good time to partner up with somebody local. Also, exposure. You may not know some of the stuff going on in that neighborhood. That's part of all the civil code. So it's really important that pay attention to that. But typically, you're going to say CAVID. If you do, and you send the TDS over without the AVID, that's an incomplete TDS. They're going to get 5 days from receiving your AVID, not on the buyer side. This is only on the listing side. It's in the contract. I believe it's 10A4, if I'm remembering correctly. But it is in there stating it is incomplete. If any of the boxes aren't marked on the TDS, that's incomplete. These are ways I know to find holes to help my clients either buy time or try and catch it on the front end so we don't let people wiggle out of time. It's, that whole offense defense thing you play when, depending on which side you're doing the file. Double check with your broker of record, verify that verbiage. However, typically it is not recommended because it looks like you're deferring your civil code responsibility onto the physical inspection versus you taking responsibility and doing it yourself. Fiduciary means transparency. Oh my goodness. I had 2 different files this month where they were not going to tell the seller some stuff that was going on. We had one where we weren't going to tell the seller that the buyer was running late, and the other one didn't want to tell the seller that we were aware that they had previously listed it with the brokerage that was buying it. Fiduciary means transparency. NAR settlement, transparency. Transparency. We are here to talk to the client. Good, bad, or indifferent. We talk to the client and we put it in writing. Have a phone conversation, circle back with an email. Thanks so much, Mr. Seller. Talking to you today was great. Here's what we discussed. Blah, 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 blah. Here's supporting documentation. Even better. Here's what you told me how to move forward. Please confirm. Again, I understand. I'm too busy, Sam. We talked. It's fine. It's fine. It's fine. I can't prove conversations that don't have documentation if you go to court. I can't prove it. Your broker can't prove it. I cannot build a defendable file without that info, without that document, without that email. These little things that seem tedious and I don't have time for it. And we're hustling so hard, Sam, and my client doesn't like that. My client only wants text. You can text them and say, hey, I'm going to send you an email because I need to document com log. Setting expectations when you start working with clients of why we have to do certain things, because we do report to the Department of Real Estate. We do get audited. It's going to happen. We are part of all these different memberships and things where we've said we will be these good people. Then we got to put our money where our mouth is, and we need to do it in practice. And explaining to your client, well, they only like text. Fine. You're going to let them know you're going to text them. And hey, in that text, I am also sending you this in an email. Send me a screenshot of that text that they said, fine, I'm not going to respond to that, but I acknowledge. Whatever you got to do, but get it in writing. It's way too important. And make sure you're communicating everything to your client. They need to know you are not party to that contract. That is one of the protections you have as an agent. If things go south, if that seller didn't disclose, if the buyer didn't actually do the funding or go through their lending this way they said. Make sure you're using all of the tools in your toolbox. Take your time and do it right. Same thing with you setting your expectation with sellers, what's needed for disclosures. We had a situation where they had a summons from the city because they were in some permit violations and they had ignored the city, and the city basically had a contract not to let us do any transaction on it. We need to know about that. That needs to be talked about. We need to let them know we want everything. Disclosures are the history of the property. They are not marketing pieces. By the time the buyer is typically seeing them here in Southern California, I know it's a little different in Northern California, they're already in love with the property. They're already interested in the property. Now we're just giving them the good, bad, and ugly, and the dirt. That's it. No judgment. Stuff happens. It's a house. You're selling it as is. It's in the contract as is. But as is means if the pool's blue when we've accepted, the pool stays blue. If the grass is dead when we've accepted the deal, the grass can stay dead unless you guys negotiate it. That's what as is means. Not all these other things. Well, I don't have to disclose. Also, there is no statute of limitation on fraud. A material facts, we can't decide what somebody else may think is material fact. If you've got it, share it. It's so much easier, so much better. Just put it all out there. I understand. Well, I've got to get this deal through, and Sammy, you don't understand. It's been a while for. I do understand. I understand how this market's been and I understand the challenges. I really do. And I want you to keep every penny you are making. I don't want it wasted on lawyers and not getting other deals because your brain's so tied up with something that went south. So that's what I'm fighting for, is to protect every single bit you're doing and make sure you get to do what you love by me doing what I love, which is sitting at home, yelling at screens, fixing paperwork. I'm weird. Has a seller listed with another agent or broker prior to listing with you? Are there already inspections? Was there already an escrow? Is anything floating around? That's known material fact to that seller, even if it's not known to the brokerage. We need to get that. We need to get those docs. We need to get everything on file. We need to make sure that's taken care of. Okay. So coming up, I've got 4 more of these I'm going to do next month. Heat TCs, I think I know why. That's what I'm going to start off with. It's interesting to see some people absolutely love working with TCs. Some people don't. Some people don't understand what are TCs and what we're able to do. So that's going to be my topic next week. Then we'll go into short sales versus foreclosures. Unfortunately, there is some issue coming up. I know with FHA, there's some things that were not disclosed. We've got some default numbers rising a little bit. Nothing panicking, but it's always good to know. It's something to be educated in, and it's another service you can offer your clients. LBSB, loan broker, sales broker, 24-hour rule. Are you a lender who also does real estate? Did you know about the LBSB? I do. And did you know that it's also a civil code issue? I do. Let's talk about it. I want to make sure you're protected. Then, of course, end of the month, here's what went wrong. I'm just going to take notes and keep growing and see what we've got. As always, verify everything with the broker of the record, the file you're working on. Please check out my YouTube channel, like, subscribe, all that fun stuff. I've got now it'll be 7, 8 videos with this one up there, adding more every week. What's a topic you'd like to hear about? I'd love to hear from you. You can reach me, cell, email, all of that fun stuff. 619-993-7264. Feel free to give me a call. Even if I'm not the TC on the file, I'm happy to talk about the stuff till I'm blue in the face. Thank you for joining me. I'm Sam Hayes. This is Why with One Stop. Have a great day.